Good morning, everyone. Hope everyone is staying warm in this nice little winter spell we are getting. While more people come in from the chat, we'll just get started on, or the waiting room, we'll get started on our general housekeeping instructions. As always, this is general information. It is not legal advice. Please don't use it as such. You can only get actual legal advice from your association attorney. And so if anyone comes to you and says, well, condo law said this, you can just tell them that that wasn't legal advice. Also, we don't really have an issue with this anymore, but please remember that the chat is for questions only and requests for clarification. It is not for legal advice or a discussion board, but this group's pretty good, so that's not an issue. If you have a question, you can unmute yourself or raise your hand, or again, put it in the chat. And then we are in a new legislative session, which means there are bills that relate to community associations being discussed down in Olympia, and we, through WSCAI and the LAC committee, there's a Monday morning minute that it actually is about a minute read, but it gives you all the updates you're looking for regarding the legislation and what's happening. We have a question about some legislation later in the chat, but the Monday morning minute is also where you'll find calls to action if there is a request for homeowner or manager or community association input for the hearings and the committees as they go through these bills. And I think that's all we have today for our general housekeeping. So we will just jump in to the first question, which is, I think Ken said last week and other times, something like, if it's not in the minutes, it didn't happen. My question: when a question is posed by the board president by email and a vote is given to that board president and a result is announced by him and acted upon, what is required to make it official? Does it have to be confirmed in the next open HOA meeting? Do people have to reveal how they voted? So this question, we weren't quite sure what the person was asking, if they were asking for association as a whole meetings, or if it's just a board meeting, or what action is being done and voted on. So we answered both. All the statutes do provide for voting by mail, but an email from the board president is likely to not count unless everyone has agreed to receive notice by email. So regardless of what type of vote you're doing for the whole association, if you're doing a whole association vote, you have to follow the notice requirements in the statute. If that notice requirement hasn't been met, you cannot have the vote by email. That is different than board meetings and a board vote. So if the board president sends out a vote via email to the board members, if you're a non-WUICOA community, you can conduct the vote via email. And if you have unanimous consent, that is a valid board decision and the board can act on it. We recommend that that vote and that action and the decisions be reflected at the next board meeting in the minutes to sort of ratify what's there, but otherwise you can, it's official when you have unanimous consent. If you don't have unanimous consent, it's not an official action. For WUICOA communities, you are limited to ministerial actions being done over email. So if it's something big like, do we proceed with the siding contract, that's probably not ministerial, though now it's could get into a debate. But basically, if it's ministerial for WUICOA communities, you can ratify it and put it in the minutes as well. And Ken, do you have anything you want to add?
Well, I would add that if every owner has agreed to electronic notice, the request by the board president would still have to comply with the voting by mail requirements, which has specific timelines on when you send out the vote and how much time you need to give owners to respond. And then there was another part of the question, which was about, do people have to reveal how they voted? And the answer is that if you're a WUICOA community, the statute was amended last year to require secret ballots, and the list of protected records was amended to say that you cannot reveal any records that would disclose how a person voted. So even without that, my answer probably would have been that the if it's an owner vote, that no, you would not reveal how people voted. Under the regular statutes or for board meetings, there is a presumption that if a motion passes, every board member approved it. And the statute provides that a board member can request that their dissenting vote or an abstention be reflected in the board meeting minutes, in which case you can essentially guess how everybody voted if only some people voted no and listed their names. But there's certainly nothing which would otherwise encourage us to require that all owners' votes be provided to the membership. Does that cover what we need to cover? We'll assume it does. People can put in another question if they have something that's different than what we covered. So question number 2, at an annual meeting of the owners, when establishing a quorum, do board members who are unit owners count towards the number of owners present? For example, a building of 20 units requires a 25% quorum. Two of 3 board members are present and 3 unit owners. Does this qualify as a quorum of 5 owners present for the purposes of conducting business? So the answer would be probably. If all of the votes are equal, then that would be 5 owners or 25%. And board members are owners, and for the purposes of a total owner vote, they get the same vote that any other owner has. So yes, board members qualify for quorum. But if you're a condominium that had percentage ownership causing the values of the votes to be different, it's possible you could have 5 owners present and not achieve the 25% quorum. So you'd need to look at what the voting percentage is for each of the people in attendance. And that can be a problem for some communities. And we've had some communities where it might be 4 of the 20 owners comprise 25% because there was a fairly significant imbalance. So you need to pay attention to that as well. Anything you want to add, Katie?
If someone owns multiple units, they count for each of their individual units. So if someone owns 5 units, they count as for the quorum as being there for each of their 5 units. It's not they only count for one. It's the only other thing I was thinking. So
yes.
Now the next one is, can you please remind me the RCW that allowed assessments to be increased greater than any limits contained in the CC&Rs? I believe the governor enacted this last year. For example, the documents say only a 10% increase. Is that no longer true? So there was a provision adopted by the legislature in 2018. It was formerly under 6490.095. It has changed this past year to RCW 6490.365, and then the specific section is subsection 2. And in short, that provision says to protect the public interest, RCW 6490.095 and 6490.525, which is the budget ratification section, supersede existing provisions of the governing documents of all plat communities and miscellaneous communities previously subject to RCW 6438. So basically, this statute invalidates any caps on assessment increases only for plat communities. So this doesn't apply to caps on assessments for RC or 6432 or 6434 condominiums. This is only for Plat communities, and that they basically said it was against public policy to have caps on assessments in Plat HOA communities. Anything you want to add, Ken?
I think cooperatives also would not be covered by this particular statute. But yeah, anything that's under the homeowner association. Question 4, if the declaration does not have any provisions that support a rule, is the rule still enforceable? So this is going to depend entirely on the type of rule and the governing documents, and I'll say the reasonableness of the rule. So as a general principle, a rule cannot take away from an owner a right or obligation that is specifically provided for in the declaration or the CC&Rs. So for example, we know because it's been tested in the courts that a rule cannot restrict an owner's right to rent their unit. And so this has been tested in the court several times. On the other hand, the statutes do provide a very vague and broad authority for rulemaking authority. So for example, in the Condominium Act, it says that subject to the provisions of the declaration, the association may adopt and amend bylaws, rules, and regulations. So that would seem to provide fairly broad rulemaking authority, especially I would say for the common areas. WUICOA has a virtually identical section that says that the board has the authority to adopt and amend rules. So it starts to become a question of whether or not you have something specific in the rules now. It starts to become a question of whether it's something reasonable. So, you know, Katie, when we were talking about this earlier, was saying, well, couldn't you adopt a rule with quiet hours? And you know, my thought is, well, you've got a general provision that says no one can do anything that's a nuisance or annoyance, and that a rule adopting quiet hours seems consistent to me with that. And so probably that would be an enforceable rule. But we also know that a rule prohibiting tenants would not be allowed. We know a rule that would be prohibiting roommates would not be allowed because there's now a statute that specifically grants or specifically prohibits enforcement of such a rule in any type of community. So if you've got a question about a rule, you're going to need to give your documents and the specifics about the rule and maybe even the purpose of the rule to an attorney to help you interpret it. Some rules, like a rule that prohibits barbecues, I think if it's got the basis in your insurance company requiring it, or as it's a safety hazard, I think that probably those rules would be enforceable. Whereas if it's a rule like no children playing in the parking lot, I can tell you that rule's not enforceable because it's a violation of the federal law. So you're going to have to talk to someone. Any other thoughts, Katie, on that?
No, I think you covered it. So our next question is, have any bills been drafted to move up the WUICOA for all implementation to January 1st, 2026 that we can review? So the short answer is there is not a bill to move up the implementation of the entire statute of WUICOA to apply to everyone starting January 2026. But there are some proposed bills to make certain provisions of WUICOA apply early. One notable one is Senate Bill 5129, which significantly applies to meetings, and Section 15 is the most significant one to note. It would require a 14-day notice for all meetings, including board and committee meetings. If there is an unexpected time-sensitive issue, 7-day notice would be allowed, provided the notice is sent electronically to all owners whose email addresses or phone numbers are known to the association. This proposed bill also allows meetings more clearly to be held online. The meeting notice must include instructions on how to join the meeting and provide a telephone call-in option. The board must also provide 15 minutes at the beginning of the meeting for members to comment on agenda items, and the board may place reasonable time limits, not less than 90 seconds per owner, and you can reduce the time, or the time limit may be reduced and allocated equally if more than 10 owners wish to comment. So that is something that is probably going to become effective against all associations. I don't know the exact start date. I don't know if they're going to do a whenever the session ends start date, or if they're going to wait till January 1st, 2026. But that provision would apply to all associations. The WUICOA trailer bill, for those of you who want to read it, is Senate Bill 5129. So in part of it includes meetings, but that's going to be some more changes. If you want to stay up to date on all of the changes happening and when they may apply, sign up for the Monday Morning Minute. That's where you can get real-time information. All right, Ken, anything to add?
Yeah, there's a group of homeowner advocates and another group of building construction professionals advocates. And then there's the Legislative Action Committee, all trying to modify WUICOA. And it looks like maybe 20 more sections of WUICOA will become binding immediately, which includes what Katie just mentioned. The developers are trying to carve out more exceptions to WUICOA for communities as large as 50 units, but only plat communities. It's, I would say, kind of a mess. And I have no idea how much of this is going to make it out of committees. But whatever makes it out of committee is likely to pass the full legislature. Next question. Would cameras in a common area be considered a capital improvement? So it depends. If there were no cameras now, then it probably would be a capital improvement, but it's going to depend on how capital improvement is defined in your governing documents. The IRS definition of a capital improvement includes replacing an existing component. So that definition does not work for interpreting our statutes or our condominium declarations. So it's going to be entirely a function of your documents, and it is not addressed in the statutes for Washington State. Anything you want to add, Katie?
Nope. So is there a law that requires that all of the members of the association vote for each board member? For example, if there are multiple sections in a community, each with a different number of homes, can the bylaws specify that each section elects their own members to sit on the board as a representative of their section? Or would that make members' voting powers unequal? So there's no law that requires all owners to elect every board member. In fact, owners don't have to vote for every board member if they don't want to. But your documents have to support not letting an owner vote for a particular board member. If there's no restriction in the documents, you can't impose one without any authority. There can be different classes of membership, and we see this typically in bigger communities with sub-associations, or even when there's some developer control still, you'll see in your documents the Class A, Class B membership. So there can be different classes of membership that can have different voting rights, but it's all going to come down to what your documents say. Look in your declaration, look in your bylaws. Your bylaws should state how board members are elected and how the voting process can take place. Some documents require a certain number of board members from certain sections. For example, we have a client that's a condominium, it's 2 buildings. Their bylaws say that there must be 1 board member from each building, and then whoever else fills it in. But every owner gets to vote for those 2, or from the pool. It's not like building A votes for building A only. But there are some associations where if you're a sub-association, you can have only the sub-association votes for particular board members to serve on the master association. And so it's all going to come down to what your documents say. And you can change your documents to say whatever you want, as long as you have the votes to amend it. So if you want to create communities voting for certain board members and not others, and you have your community behind it, go for it. Ken, anything to add?
Yeah, the last part of this asks, would it make the members' voting powers unequal? And the answer is that in many condominiums, the voting power is already unequal because the voting is based on the percentage ownership interest. In many mixed-use condominiums, there is a requirement that the commercial unit owners get to elect a certain number or appoint a certain number of board members. We've got one client with over 300 units. There is one commercial unit, but the declaration provides that commercial unit gets to elect 2 of the 5 board members. Now, I don't know why it was written that way, and certainly the committee could amend it if they chose to, but it does give the commercial owner 40% of the voting power on their board of directors. He doesn't care to exercise it, but it's the way the documents were written. Next question. Is there a standard timeline for retaining rules violation complaint forms, notice to owners responses, and all the paperwork involved? For example, a noise complaint that does not turn into a recurring issue. So the short answer is yes, that the record statute says that it would be 7 years. If you're a condo, that would be 6434 372 subsection J. So all materials relied upon by the board or a committee concerning a decision to enforce the governing document shall be held for a period of 7 years after the decision is made. WUICOA has virtually identical language. Okay, so it may be that it's easy to hold it longer, but the 7 years is stated explicitly. So anything you want to add, Katie?
We have another question later about records. So if you have any questions that come up in the meantime, put them in the chat. So our next question is asking for a friend who is thinking of selling her condo. Does she need to reveal to the realtor and the buyers that a major siding project is coming, even though the board has set nothing up and there are no particulars or special assessment details? So first, we can't fully speak about what an owner's obligations are to disclose and what representations they must make. But we have seen a purchaser successfully sue a board member who sold them a unit when the board member knew the siding required replacement, and the court did order the seller to pay the assessment. From the association's perspective, there are things that should be disclosed, and this is when you get the reserve, or you have your resale certificate, and it lists, and the statute has a list of what must be disclosed. And so part of that may be an upcoming special assessment that the board's aware of. Other information is the reserve study, and the reserve study should provide information about all upcoming major repairs and how the association is funded to make those repairs. If there's been discussion about the repairs during board meeting minutes, then that should be reflected in the meeting minutes and disclosed with that resale certificate. WUICOA requires that 12 months of board meeting minutes must be required with the resale certificate, or provided with the resale certificate. So you have to disclose that information. It may not be as clear as we have a contractor and they start May 15th, but the discussions should be provided to prospective buyers. From the association's obligations, you don't need to disclose uncertain future projects if they haven't been discussed. So if one board member is sitting and thinking, you know, I think we should get our windows repaired, and it's not in the minutes, then what are you supposed to disclose? But all that said, just because you might not need to disclose something doesn't mean you shouldn't. If the board knows that they're going to propose a special assessment and has all the details, it is a bad idea to not disclose that information in the resale certificate. So even if it's in the bottom part where it's like additional comments, putting potential buyers on notice is a least risky option versus trying to hide it. Ken, do you have anything to add?
I think you've covered it. Question 10, the HOA declaration and bylaws require the HOA to mail owners notices for meetings. The property manager requires owners to utilize their portal to pay dues. To sign into the portal, the owners must approve the terms of use, which then require owners to accept receipt of all HOA communications by email. So effectively, they're trying to force every owner to provide notice or an agreement to receive notice electronically. So without accepting these terms, owners are not able to log into the portal and pay their dues. So question, do you have ideas or suggestions for owners that want to maintain receipt of mailed notices? So this is I would say, an interesting question in a gray area of law. We personally believe that it is not appropriate for a management company to be able to sort of strong arm owners into allowing for electronic notice in order to pay. We might say that owners should simply pay by check instead. But I also know that there's an increasing trend where associations do not want to allow any form of payment except the electronic payment. And I don't know how they're, enforcing that. Certainly the statutes don't require that payments be made electronically. And so the question may be answered if you check an agreement to the terms of use, you may have just agreed, and you certainly are knowingly doing that if you're the person writing this question. Part of the answer may be that it should be possible for you to print a document showing you've made every payment off of the portal. So if you can print that, then that should be just as good as a receipt of notice or holding a coupon that you may have had in the past. So in part, we don't really know what the answer is. It is an unsettling trend in our industries with condos and HOAs, where the management companies are dictating more how associations must do things. And I don't have an answer for that. I'd want to hear your thoughts, Katie.
I don't like any forms of contracts of adhesion, which is basically like when you have to accept the terms of service for like your iPhone or for anything like that. I think they're sneaky. But I don't know how you would handle the clear right of owners to opt out of receiving notice electronically that's in the statute. So I thought this was an interesting question. It's like a thought experiment sort of thing.
And I guess I would suggest too that if you have a specific problem with your association or manager related to this kind of payment, I would first try and work directly with them to see if you can work out a solution, which might be that you still get to mail in your check or you can photocopy a receipt. I don't know what the answer is. If you don't have a way to work out a solution, then you may need to contact an attorney. And I don't know if the association might do that on behalf of all owners, or individual owners might have to do it because they are essentially in disagreement with their association. All I got.
The next one is, there's an association with a few people past due on paying their assessments more than a year since a payment was made. There are liens on these properties already, but the dues aren't high enough to reach the threshold of foreclosure or other legal action at this time. The board is wondering if they can cut off amenities like yard mowing and pool access to these homeowners until they are paid up. So as it is with a lot of enforcement questions, this depends on your statute and your governing documents. Foreclosure is not the only remedy when an owner stops paying their assessments. Your association attorney can send a demand letter, negotiate a payment plan, and file a personal lawsuit to obtain a judgment, which they can garnish the owner's bank account and/or wages. The board could also consider a small claims lawsuit, and that is sometimes a more realistic option when the amount due doesn't meet that threshold requirement, but it does require the board to take that action. The association's attorney can't appear in small claims court on behalf of the board. So some board member or the manager has to do that process. We say don't let delinquencies get too old. Even when they aren't enough to support foreclosure, there are still these other options that I just listed. The larger and older they are, the harder they are to collect. So that's the first half of the question. What to do if it's not enough to reach the threshold. For the second half of the question, cutting off the amenities, yard mowing, and pool access. Again, it depends on what your statute and governing documents say. For example, RCW 6432-200, which is for the old act, allows the association to sever all utilities with 10 days notice of the delinquency. But you probably have other ways to reach that foreclosure threshold, so you may not need to cut off utilities. If it's supported by the governing documents, we can probably support denying access to the pool or another amenity like the fitness room that is not necessary for the use and enjoyment of the property. But you should talk to your association attorney about what you want to do. You also have to look at what amenities or things you're restricting, and is it reasonable even if you have the right to. For example, right now, even if you had the ability to cut off the heat, we don't think it would be reasonable to cut off the heat in the middle of winter. We also don't think that you can deny access to the owner's ability to access their unit or to their mailbox. WUICOA RCW 6490-405 subsection 2 does allow the association to suspend any right or privilege of a unit owner who fails to pay an assessment, but prohibits the association from denying an owner or an occupant access to the unit, their limited common elements, or any common element necessary to access their unit. It also prohibits the suspension of owners' voting rights, and it prohibits withholding services provided to a unit owner by the association if withholding the service would endanger health, safety, or property to any person. So that goes to the you can't cut off someone's heat in the middle of winter. In terms of the specific amenity you want to cut off, for like lawn mowing, consider what it would do to the community. If you stop mowing the lawn, the property is probably going to become an eyesore. They're not mowing it. You're not going to have that same motivating impact you're looking for because they probably don't care if it's mowed. So denying pool access, probably reasonable. Denying utilities, no. Denying the right to vote if you're a WUICOA community, no. But it all depends on what your documents say, what your statute says, and we recommend consulting with your association attorney before doing anything, especially when someone is delinquent and has liens against the property. Ken, anything to add?
No, I think you covered it. So next question. What can take place at an annual meeting if there is no quorum? I.e., there are not enough owners in attendance, either in person or by proxy, to meet the quorum numbers in the governing documents. Can the board approve anything? Can board members still be elected? Should the meeting be rescheduled? Is there documentation concerning this in the RCWs? So the short answer to the question is that no action can take place at the annual meeting if there is no quorum. Okay. You adjourn and reschedule if you don't meet the quorum requirements by statute or your governing documents. You cannot elect board members, but board members always have the authority to appoint a successor to fill a vacancy. Now, this is not the same as someone's term ending. If the term of a board member ends and you don't have a quorum for the annual meeting, they continue to serve on the board until their successor is elected. And so that would mean until the next time you get a meeting with a quorum. This has been tested in the courts a few times, and the courts have upheld boards which have been appointed without a quorum going back 7 to 10 years. So the board does not get to approve anything which is supposed to be an association action. Okay, so if you needed a vote of the membership to transfer surplus operating funds into reserves, theoretically, you don't have the ability to do that because you don't have a quorum of the total community. If you don't get a quorum for a budget ratification meeting, it doesn't matter because the default there is the board approved budget is automatically approved. So usually the only important matter that's occurring at the annual meetings is the election of the board. And so you can try scheduling another meeting and get more proxies to try and get a quorum so you can elect a board. You can try doing an election by mail in accordance with the statute as a way of trying to get more participation. If you do an election by mail, you still need to meet the minimum quorum requirement by getting enough owners to participate to meet a quorum. Anything you want to add?
Nope. So next question is, does the special assessment ratification process provided by RCW, I'm going to give the RCW 649525, overrule the condo bylaws that states 60% vote is required to approve a special assessment? Our short answer is probably. It largely depends on what you're doing, how big the special assessment is it actually a capital improvement, and is it likely to challenge? So RCW 6490-525, which applies to all communities, says that unless at that meeting, the unit owners of the units to which a majority of the votes in the association are allocated, or any larger percentage specified in the declaration, reject the budget and the assessments against the unit included in the budget are ratified, whether or not a quorum is present. So your documents can require more to reject, meaning your documents could say that 60% is required to reject a budget. That is not the same thing as 60% being required to approve a budget. So it may, like I said, it may depend on what the assessment is for. If it's for a capital improvement, that would require affirmative approval, but that is for the ability to spend the money, which is different than the ability to collect the money. So the special assessment is the ability to collect the money. Paying for a capital improvement is the board's ability to spend the money. So there may be a time where you both need 60% to not 50% to not reject, but then 60% to approve the spending. Ken, do you want to add anything?
Yeah, just when you get into these questions, there end up being a lot of very specific details. And while it's pretty clear for the homeowner association communities under 6438 that no approval is required, it is not as clear for condos. And so we start looking at, well, how big is the assessment? How likely is it to be challenged? And those start to be factors in risk management and how the board conducts its business. Next question. Can monthly homeowner association meetings be held at the property? Now, I'm going to assume they mean board meetings. A resident said this is not allowed. This is new to me. So the short answer is yes, of course, board meetings can be held at the property. Most bylaws do not specify where a meeting has to be held or can be held. So basically, it's pretty much at the discretion of the board. If the bylaws say that a meeting must be held at a certain location, like a library or community room, then we could certainly support holding it elsewhere per the meeting statutes, which say that it can be held at the community. Since you can hold meetings electronically or over, the computer, we think that you can hold a meeting at any reasonable location. But again, it depends where it is. UKIOA was actually written to require that meetings be held at the common interest community or a place convenient to the common interest community. And this is in 6490-445 subsection 2D. And it requires that during the period of declarant control, at least one of the meetings be held at the common interest community. And after transition to a board of owners or purchasers, all board meetings must be at the common interest community or a place convenient to the common interest community. And I think that is to facilitate the owners attending the open meetings and giving them an opportunity to comment. Anything you want to add, Katie?
Nope. So the next question is RCW 6490-495 specifies retention periods for many, but not all items on the list. And so everyone's on the same page, it's the records statute in UKIOA, which does list what you need to keep and for how long for most of them. So the question is, what time period would apply for each of the provisions that don't list a specific time frame? And the default in 6490-495 is that the association must retain it. If there's no time listed, that means forever. If there's no exception. So just going down the list that was submitted, subsection 1B is meeting minutes of unit owners board and other committee meetings. Our answer to that is those are permanent records. You have to keep them. The next one is subsection 1N, which is copies of all notices provided to unit owners or the association. And technically there's no time limit on this. So I know my general rule was you have to keep it forever, but in practice, it might not make sense to keep all of them forever. You only keep ballots for 1 year and amendments cannot be challenged after 1 year. So it is likely that notices could be disposed of after 1 year. The notice might be part of the meeting minutes and then it would be permanent, but given that you can keep electronic notice copies of the notice, you can keep them longer than 1 year. The lowest risk option would be to keep all these notices longer. If it's a notice of a violation to an owner, you could apply the 7-year requirement that is found elsewhere for violations and materials related to that. But again, lowest risk option would be to keep it forever, especially because if it's stored electronically, it's pretty cheap. Subsection 1P is originals or copies of plans and specifications by the declarant. Those keep them permanently. 1Q, original or copies of any instruments or conveyances of any common elements included within the common interest community, keep those permanently. And then 1R is originals or copies of any permits or certificates of occupancy, keep those permanently. So like I said earlier, the short answer is if there's no time limit set, keep it forever. Otherwise, follow what the statute says. Ken, anything to add?
No, I'm good. So next question, this is the last one that was submitted in advance. Our building needs a new envelope. Do we have a say on how many bids? Question mark. Work done in our building has been mediocre and nobody seems to be bothered. Parentheses, we think it'll be a couple $1 million and our dues will be much higher, in parentheses. So I'll say the short answer for me is that the statutes do not govern how many bids you get or how you perform work on your building. Your documents may have something specific about a number of bids. And then if it is silent, as I would say most are, then the board needs to act reasonably. And that reasonably may or may not include getting multiple bids or having the owners have some kind of a vote about the bids. The owners will have an opportunity to vote on ratifying a budget if bids or no bids are accepted. So if you felt like the board did not get enough bids, you could certainly vote down the special assessment to fund a project and explain to them that that's your reason for doing it. If enough owners object, then the board could be forced into getting multiple bids. We've certainly seen a couple of communities that have done negotiated contracts using a architect or engineer to help with engineering the scope of work to try and save money. And it is something that might be faster than getting multiple bids. You know, it's easy to say that getting 3 bids is a reasonable thing to do, but I also have seen a number of clients where it just was not possible to obtain multiple bids, especially if it's an unusual or specialty type of work. So for example, replacing the fire sprinklers in a building where there are a very limited number of vendors. It may be that your governing documents have in the damage and destruction portion a requirement that the board obtain at least 2 bids from reliable contractors in preparing the information to disclose to their owners about the damage which occurred and for the owners to vote on restoration. That provision was written assuming there was a major fire and you're going to rebuild a whole building. And we don't know whether or not that would apply to replacing a damaged roof or a roof which is just worn out, especially if your document happens to define damage as something which occurs suddenly or over an extended period of time. And we have some of them that state that the damage is no matter how slight, it still requires that process. And most of our clients ignore the process that's provided in the damage and destruction provision. And for the most part, it doesn't matter. But if you've got an owner who is trying to attack procedurally what the board is doing, we would recommend that you follow the procedures provided in the document. Anything you want to add?
Nope. We do have some questions from the chat, so I think we'll just move to that one. The first one is, how can we make comments to the legislative committees about the bills? I'll start and then let Ken answer, because I'm a little more unfamiliar with Washington's legislative comment process, but sign up for the Monday Morning Minute, and that should have information about how to contact your legislator. I think there's also like a if you have questions option to email, and that can either go to the LAC or you can ask the LAC how to contact your legislature. And I'm sure also you could Google it, but I don't know what that would be.
Well, I'm going to offer first, you can figure out who your particular representative is. You will have one senator and one representative that is for your geographic location. And you can try talking to that person directly by email, is probably the most likely way you could reach them. You can find out the committee which is handling a particular matter. And I think that's listed on the website where the bill is being considered. And I think that there are ways to send an electronic notice to that committee directly. You can submit it to our Legislative Action Committee and hope that the committee will submit it. But you've got another filter if you do that, because the committee may not care to put forth your particular comment. And if you make a comment to the committee, you are taking that risk. You are either going to empower the committee to have more strength when it talks to the legislature, or they're just going to say, well, we can't do everything that all of our people want or need. We need to focus on a small number. And I think that's usually the approach that the LAC takes. They're trying to focus on the things which have the most likelihood of having an impact and the most likelihood of effectively influencing the legislature.
Yes. The next question is, a declaration states the purpose of the association is to improve member health. What actions does this text obligate the board to take? I don't think we can answer that.
Yeah, I guess I would have to know more of the text of the document and more about the community. If you had, I don't know, I'm trying to think, we have some communities that are run more like cooperatives or they're co-housing communities, and they do community activities on a regular basis. Like they have a shared meal every Thursday night. And so one could argue that, well, that obligation to promote the health of the membership means that the meals have to be healthy. Oh, you can't just order in pizza every time. So I don't think we can answer more than that. I think it'd be hard to specify that it did anything as a specific obligation for the board.
Yeah. All right. This next one is there any value in taking notes if you do not meet quorum at the annual meeting? I don't think it could hurt. It doesn't hurt to have a note that says you didn't meet quorum. They're not, the notes aren't going to be actual meeting minutes, so it's not going to reflect any action taken. But if there is a small discussion about when to schedule the next annual meeting or how short of quorum you were, those notes can just be helpful moving forward. Again, they're not reflecting any action and there was no meeting, but you can also take your own notes about whatever you want.
Yeah, so I'll offer that it could be helpful if you are trying to create a record of accomplishments of the association in the prior year. We certainly have clients that do that. Those are not action items so much as they are reports. And so you could just have a report filed by the officers of the board, which state those things as well. If you did know you were going to have some significant change coming up, you're providing an informational meeting to the people who did show up. And it would be okay to make notes about the information which is being shared with the membership. So if you're changing management companies, or you're anticipating a large special assessment, or you're going to prune all of the trees or something which you're trying to notify owners, you might still want to produce a set of notes and maybe even send it out to the owners after your failed meeting in order to make sure that there's a documented effort to inform the owners about a change coming up.
The next question, how to deal with saboteur. A board member was appointed 2 months ago and is recording members without consent and sharing screenshots of board text group communications with non-members to highlight the board's faults. We're concerned that this behavior will drive more volunteers away. This person has been a problem. So without addressing the specific situation of what's going on in your community, we can touch on the recording issue broadly, in that there is no expectation of privacy in a board meeting when you're holding yourself out to the public. So if someone is recording separately without Zoom, because like Zoom asked you all if you consent to the recording, that's through our Zoom platform. But you can, I could be filming it on my phone behind me, and I'm not, but no one would have any idea of knowing. I'm holding myself out to the public. I don't have an expectation that someone won't record me. You can always ask someone to stop if you know about it. It's just harder to have any teeth that say you can't do that. If you really don't want to be recorded, or you think someone's recording you, you can leave the meeting or stop talking and sharing.
Yeah, I'm going to give it a slightly different bent on this answer. And my answer would be stop conducting business outside of board meetings. UKIO is specifically written, and the HOA Act is specifically written to try and prevent board discussions outside of open board meetings. So if you are sending emails and discussing matters, you are sending text messages and discussing matters, you are not in compliance with the requirements of the open meeting intention of the legislature. And so one way to prohibit those kinds of conversations being recorded and transmitted is stop making them. And yes, it is going to seem less efficient. And that's our biggest objection to UKIOA from our current boards, is that they cannot conduct business via email and text. And that's true, they cannot, because the legislature is specifically stating they want those discussions to be held in open meetings where owners have an opportunity. And so the saboteur in this case is holding you accountable for compliance with the practices that your legislature intended.
So there are some follow-ups that I think we have time for related to that question. Another thing, if you don't want to be recorded, it is your private conversation, and you're allowed to, you're not a UKIO community, put everything in writing. If you don't want to be recorded, do it as an email. The follow-up question is, what about one-on-one communication between the president and the chair to figure out financial questions so we can present them to the rest of the board coherently? So basically, I think the question is, you're supposed to be planning for the board meeting or the association meeting. How do you do that if you can only do things at a board meeting? Which I would think the planning of the board meeting, presenting the financials, making the PowerPoint, that is all, I think you could argue, ministerial. You're just doing it to set up. You're not taking any action or decision, and you're not discussing what the financials mean. Just, do we include the receipt from Joe's lawn mowing? Yes, sort of thing.
So none of this has been tested in Washington courts. And so we don't really know what the limits are between something being considered a board action. If you were only talking about how you present information, I think the risk is low that you're going to be violating the open meeting requirement. If you are making decisions about whether to disclose a future special assessment for a siding project, I think that that is a discussion item, and it should be discussed in the board meeting rather than privately by a subset of the board. And if you've formed a committee, which you're allowed to have subsets of the boards and committees, you still have to follow the requirements for any committee which can take action on behalf of the board. So you'd still be doing it with that. So, you know, without having more specifics, we cannot give you advice on whether or not a communication between two board members is a violation of the open meeting provision or not.
And with that, I know there was one more question submitted, but it's too long for us to get to with this last minute. So I think this is a good place to stop. Thank you all for attending today. Please send your questions to info@condolaw.net by 4 p.m. on Monday for next week's Q&A, and we will see you there. Bye.